Noe, you can hear me? Okay, and you're muted. And Ms. Horton, you can hear me as well?
We can, Your Honor. Thank you.
All right. So this is in the matter of Rebecca, is it Pillar or Pillar? Oh, wait, let me turn off that. How do you pronounce the last name?
Pillar, Your Honor.
Pillar. All right. This is in the matter of Rebecca Pillar versus Keith Pillar, file number 2011-425 DM. We have, is it Carly?
That is correct. Yes.
Carly Horton, P71338, appearing on behalf of the plaintiff, and Margaret M.S. Noe, appearing on behalf of the this case was sent over from Hillsdale County, and we are here today on a motion to enroll the child in counseling that was filed by Ms. Horton on behalf of her client. So, Ms. Horton?
Thank you, Your Honor. Yes, this is our motion. And as I indicated in our motion, there has been a long history of litigation in this case. At this point, we're only asking for this specific order with respect to Madison, who is 13, the younger child. There has been in a prior hearing, this was before my involvement in the case, but there was some counseling that these children were involved in several years ago. And it's my understanding that that counselor was called to a court hearing, and the judge at the time that was presiding waived the children's HIPAA rights. And so the counselor was required to share some information that the children had shared. And my client's concern going forward is that that not occur. This child has had some serious anxiety, depression, made some suicidal statements that have been very, very concerning to my client. I had reached out to Attorney Noe. We've had some correspondence back and forth attempting to address it. Unfortunately, we haven't been able to reach an agreement on that, but it is very much a concern for my client that this child be able to talk to someone without any fear of retribution from either side. And so we have filed this motion asking for the court to order that she can attend professional counseling, and that that counselor would not be required to share any of her statements with either party. I think that is the biggest concern, that she won't actually participate in the counseling, won't actually get the help she needs if she doesn't feel like there's that protection in place. And as far as choosing the counselor, I would leave that up to the court's direction. I would hope that Attorney Noe and I could perhaps agree on one, but if not, we'd certainly leave that to the court's discretion. Thank you, Your Honor.
All right. Thank you. Mrs. Noe. You're muted. Mrs. Noe, you're muted.
Thank you. Thank you, Your Honor. And I don't necessarily disagree with Ms. Horton's statements. However, I would indicate that when the parties, before my participation as well, in 2015 appeared before Judge Smith would not waive or would not agree that the child had HIPAA rights, and would not agree that the parents should be precluded from hearing the child's mental health issues before a counselor. We believe that the child, if the child does need counseling, we want the child to have counseling. The problem is that the last time we were in court before Judge Smith, we were there because the child was engaged in some serious TikTok behavior, and it took us appearing in court to stop the child from using TikTok. We weren't able to get mom to cooperate with us. In fact, mom herself was using emailing activity to be critical of my client's wife, the children's stepmom. It was nicknaming other kind of immature behavior going on that was just not appropriate. The parties just cannot agree in that regard. If the child has been threatening to hurt herself, my question would be, why hasn't mom reached out to dad? That would be really important information. We want the child engaged in counseling, but we want the counselor to be engaging with these parents. I wish the parents could sit in with the counselor and say to the counselor, what does this child need and what can we do as parents to help this child to be healthy? But precluding the parents from being aware of what the child's needs is not the answer. We would ask the court, and I think that Ms. Horton and I can work with the court. If you know the names of therapists, I think Ms. Horton, between her county, our counties, and everybody, would we together, if we can find, and would defer to the court's recommendation for a therapist for this child. My client wants the child to have a therapist. We would defer. He's got an insurance through the, he works as a Michigan State police officer. Would be happy to help find a therapist, but we don't want either parent precluded from that information. We want the child precluded from engaging with either party inappropriately. In the past, that has been the problem. That mom pushes it off on dad and stepmom are the problem here. We don't want that. And if working with a therapist in a healthy way can include that, that's great. We want therapy, and we just don't want mom misappropriating that. We want to work with the therapist. Please don't let dad be outside the therapeutic relationship. He's never misappropriated that, and he would not now, and he would want mom precluded from doing that, and he'll follow those same rules.
Ms. Horton, anything further?
Your Honor, just briefly, I would indicate that I did reach out to Attorney Noe when my client first brought up these concerns about suicidal thoughts and concerns about the child's mental health in order to try and address them. The parties communicate to the extent that they can, but it is minimal. And I would indicate that the concern here is that the child is not going to feel comfortable discussing this with either parent. That's why we need an objective third party. And based on the long history of this case and the litigation involved, I think there are very serious concerns that the child's going to feel a lot of influence and a lot of pressure to share whatever is being discussed with the counselor, or that the counselor is going to have a lot of pressure for that to be shared. And that's what we're trying to avoid, to create an atmosphere that the child feels comfortable actually getting help. Based on the history of this case, I don't think that it is going to be the case that if both parents can have that conversation with the counselor, can interject and require the counselor to disclose what the child is saying, that the counseling is going to have any benefit to this child.
Okay.
All right, Your Honor.
Sure.
Thank you. Very briefly, counselors, I think, make those decisions every day. And when the interaction with the child presents itself, I trust the counselor to find an appropriate mechanism to share with the parents as is appropriate. You trust that. And if I misconveyed that to Ms. Horton, I apologize. We would trust the counselor to share the information with the parents as appropriate, but I do not want the father precluded from being a part of that therapeutic communication.
Thank you, Mrs. Noy.
Thank
In
you.
this case, Mrs. Noy, you're correct. The counselor should have the ability to communicate as they see fit to the parents and involve the parents as they feel necessary. But I do believe that a child should have a safe place. Otherwise, counseling is not going to be productive. So I am going to grant Ms. Horton your request to enroll the minor child in counseling. And this is Hillsdale County, so I don't know of any counselors in Hillsdale County. And neither party shall interfere, nor shall the counselor disclose any statements made in counseling to either party unless she feels it's necessary. She is a mandatory reporter. So there is that aspect. So we'll grant your request. But as I said, this is a Hillsdale County case. I don't know of any counselors in Hillsdale County to give you any recommendations.
Your Honor, we would request a counselor in Lenawee County based on where the parties are at. This is a Hillsdale County case, correct? But my client actually indicates Lenawee County would probably work better logistically for the parties if the court has a direction on that. Mrs.
Noe, would you agree, Lenawee County?
Yeah, I don't have a problem with that. I do have a question, however. I don't have a problem. I don't know who necessarily, I have some people who could make some recommendations, and I've shared with Ms. Horton that I would be happy to help that. I do have a question, Your Honor. You said that she's not to disclose any information provided to her, to either party. Is that just a blanket non-disclosure, Your Honor, or may I ask if she may use her discretion or his
I
discretion?
did say it unless she felt it necessary to.
Oh, I'm sorry.
So I'm leaving it to the discretion of the counselor.
I will work with Ms. Horton if that's all right. Carly, with it, are you comfortable working with me to arrive at a therapist?
Yes, we can certainly work through that, Your Honor.
Okay, all right, very good. Anything else? All right.
And then the counselor would be provided with Mr. Pillar's insurance information as well. Ms. Noe, is that correct? Just want to make sure.
Absolutely.
All right. Thank you, Your Honor.
All right, thank you.